Legal recommendations. This article has tracked down some legal vacuum that may be addressed through recommendation to the government of Bangladesh and the IMO for immediate implementation, where stakeholder consultation may not be an immediate necessity. The recommendation may be enumerated as follows. Recommendation for Bangladesh. A streamlined test review procedure should be arranged before importing any ship for recycling in Bangladesh. The example taken by India in this respect can be used as an example. A measure should be implemented to turn the ship back from the territory, including penal provision if the vessel doesn't fulfill the procedures set out in domestic law. Special consideration to be given to avoid any possible fate accomplished of EOL ship in Bangladesh territories. Reform of labor laws to reflect strong collective bargaining right and trade union right. Removal of numerical threshold to allow the temporary workers to claim benefit under the Labor Act 2006. Otherwise, ensure a permanent pool of workers in shipbreaking industry, address the gaps that exist in the employment of child labor as identified in existing research, and hold the owners of the shipbreaking yard liable instead of the miners' guardian where miners engage in shipbreaking. Ensure regular physical inspection with direct involvement of inspectors from the competent authority instead of relying predominantly on private safety agencies. Creating swift and enhanced procedures to redress the grievance of workers at ship breaking facilities by introducing ombudsmen rather than relying exclusively on expensive state court. The courts are time-consuming and expensive and ineffective in aiding workers in the shipbreaking industry. Review penalty provision and introduce corporate crime and strict liability regime applicable to the shipbreaking industry. Enhance the standard of the appointment of contractors engaged in shipbreaking industry with defined responsibilities. Ensure a purchase disclosure policy for shipbreaking facilities by incorporating the policy in the Ship Recycling Facility Plan or SRFP. Address the conflict of interest issues that arise in the administration of rules and enforcement of the laws in the ship recycling facility. Set a threshold of import by implementing the policy outlined in this article, incorporating the primary stakeholders of the industry. Consider regional cooperation between India, Pakistan, and Bangladesh by using an existing cooperation scheme such as SAARC or South Asian Association for Regional Cooperation to ensure uniform technical, financial, and liability procedures for countries using batching method of ship recycling until a wholesale reform is initiated through a competent international organization such as IMO to reflect the interests of this developing ship recycling nation. Recommendation for the International Maritime Organization or IMO. A compulsory funding mechanism need to be developed to invest in ship recycling infrastructure in locations where ship recycling has been traditionally proved feasible, taking note of the socio-economic and geographic condition of those state and location. Contributions should come directly from key stakeholders, including flag state, ship-owning nation, ship recycling state, donor agencies, international organization, ship recycling and owners association, taking into account the principle of common but differentiated responsibilities. The competent international organization or IMO may be entrusted to manage and administer the funds proportionately to the ship recycling state based on their previous track record of shipbreaking in terms of volume of ship recycling. The policy may be reviewed at intervals of every 5 years when a vessel is destined for recycling by its owner. Under a single journey exception, the flag state should issue a registration for a special end-of-life voyage. No cargo should be carried on board during the last journey of a ship toward the recycling facility. The administration of an EOL ship shall be taken over by the flag of the recycling state where the ship is destined to be recycled. Freedom of navigation shall be limited to EOL vessels by prohibiting their registration with black and gray listed flag. There should be a state-to-state level consent requirement before an EOL ship proceeds to the recycling facility. A streamlined communication procedure may be implemented to facilitate a prior informed consent or PIC requirement. Distinct responsibilities should be allocated to all intermediary stakeholders, namely contractors, subcontractors, cash buyers, and leaseholders of authorized ship recycling facilities. Separate technical and financial provision to be introduced for beaching method via an international ship recycling convention. Compensation to be ensured for unavoidable environmental degradation and social and health injuries arising from shipbreaking activities in ship recycling state following the polluter pays principle. The compensation in the form of a surcharge to be collected by the recycling state from the EOL ship owners according to international laws and a standard policy set by the recycling states. A verified publicly available online record of IHM should be maintained by each ship against its IMO number at their own cost. The information on the IHM may be updated whenever a new inspection or a structural change is made of the ship. This online information may remain available as alternative to the hard copy of IHM kept on board. Considering the special risks involved in shipbreaking, labor laws of shipbreaking state should be streamlined and harmonized to avoid unfair competition in the international market. A specialized international regime like the Maritime Labor Convention may be implemented for shipbreaking workers as an alternative. A pool of permanent workers should be maintained in all shipbreaking facilities, along with standardization of training requirements for shipbreaking workers. Streamline penalty provision for deliberate violation of legal provision by ship and ship recycling facilities should be adopted, along with provision on timely disposal of the complaint procedures. To enhance public accountability, a streamlined disclosure policy about the activity of recycling facilities and EOL ships should be implemented in international laws. A mandatory liability insurance policy may be implemented against the ship recycling facilities for workers' injuries and pollution of environment. Manual handling of work in shipbreaking facilities should be minimized to the extent possible based on the feedback received from the dominant stakeholders in the ways prescribed in this article. Streamlined downstream waste management procedures should be included in international law to ensure environmentally sound management in shipbreaking. This article has identified three pillars of success for the safe and environmentally sound recycling of ship, namely the ship recycling method, the pre-cleaning method, and the distribution of the fair shares of financial responsibility where policy reform is necessary. Steps should be taken as soon as possible for the necessary amendment to the Convention, taking note of the feedback received from key stakeholders as pointed out in this article. Thank you.